One system holds the truth, another never sees it. And when the corporate veil hides behind the silo, justice is left in the dark. Good day, and welcome to Silence Screams Loud Strength. I'm your host, Samantha. This is Unmasking Justice series. So today, we move into one of the most critical structural failures within the legal system. A failure that does not come from lack of law, but from the way systems operate in isolation. We are dealing with three powerful elements today: the company law, the alter ego doctrine, and what I define as the silo problem. This is not theoretical. This is not academic. This is not the space where truth is either revealed or deliberately fragmented, because across the UK and the regulatory framework, information is not held in one place. It is divided. So HMRC holds financial truth. Companies House holds corporate truth. Land Registry holds property truth. So courts rely on disclosure or disclosed truth through Form E. And when these systems do not communicate or connect, truth becomes optional. Today, we build directly on the understanding we have developed throughout this whole series. So, we have spoken about procedural advantage in previous episodes. We have spoken about disclosure failure. We have spoken about financial distortion. We have spoken about impartiality. We have spoken about participation impairment. Now we move into the system itself. We move into how truth is stored, how truth is divided, how truth is presented, how truth is concealed, and how justice fails when each institute holds one fragment of the reality. Our focus today is on companies law and the doctrine of the alter ego and the practice of lifting and piercing the corporate veil within family proceedings. This is not abstract legal theory. It is not something that only applies in high-level commercial cases. No, it is a critical area that determines whether the truth is revealed or hidden, whether assets are properly accounted for or deliberately concealed, and whether justice is served or defeated by structures and systems that are designed to separate and isolate information. We live in a legal system where companies are recognized as a separate legal person. So the distinction from the person who owns and manages or controls them. The principle is fundamental to commercial law. It is established and protected under the Companies Act 2006. It has been confirmed by case law over many decades. The purpose of this, though, the principle is clear: to protect businesses and business owners in commercial settings, to encourage investment, to provide clarity in transactions, to allow people to operate in the economy with certainty about their legal position within that company. But this protection is not absolute, because the law never intended for corporate structures to be used to conceal assets, avoid obligations, mislead the courts, or distort financial reality. There are clear circumstances where the law will recognize that a company is not acting independently. It is merely the instrument, the agent, or the extension of an individual or a group of persons. So when that happens, the law can disregard the separate legal entity of the company and treat it as the asset, income, and activities as if they belong directly to the person behind it. So this is in an area rooted in statute, legal principle, professional standards, and the integrity of the legal process within England and Wales. And it is directly and profoundly impacted by what I call the silo problem. Because information about individuals is held in court, tax records, Land Registry, and official filings or files, while information about the company is also held separately in a different place under different rules. So this separation creates challenges within the family law. It makes it difficult to see and connect these elements together. It makes it difficult to prove the truth and the true position of each individual or the owner of the company in that setting. It makes it difficult to ensure that all relevant facts are brought together and considered properly within a hearing FDR. So today we explore every part of this area so that we can understand, and we will look at what the law says, how the principles work in practice, and how they should be, how information is stored and shared or not shared between systems. So how corporate structures can be used legitimately and what the law allows, and how they can also be misused by those that know how to do it. We will examine legal frameworks, standards, powers, and remedies. And we will see how these tools work together to reveal the truth, even when people and the organizations try to hide it and behind legal structures and divide these systems. So, the foundation of separate legal personality and its limits. At the foundation of companies law is one principle. A company is a separate legal entity, which means it's a separate person. Under the Companies House Act 2006, once incorporated, a company exists independent of who owns it. So it can own assets, it can enter into contracts, it can hold its own liabilities, it can operate financially, it can exist beyond the individuals behind it. It can own property, land, buildings, assets in its own name. It can enter into contracts, contract agreements, and transactions. It can borrow money, take on obligations, and incur debts. It can sue and be sued in its own legal name. It can keep its own financial records and accounts filed at Companies House. Because of this The people who own or run the company, shareholders, directors, and officers, are generally not personally responsible for the company's debts or liabilities. Their financial risk is limited to the amount they have invested in the company. So their personal assets, such as their homes, savings, or personal belongings, are usually protected from the claims of the company's creditors or those who have legal claims against the company. So this principle protects investment, it protects commerce, it supports economic growth. It has served the economy well for generations. Okay, it allows people to take business risk, to invest capital, and to operate with confidence that their personal lives and property are separate from their business activities. Okay, so it is a bedrock of commercial certainty. Without it, investment could slow down. Businesses would become far more complicated. So economic growth would be severely restricted. So let us be clear. Separate legal personality is not the enemy. A company is not improper simply because it exists. A company is not suspicious simply because it holds assets. A director is not personally liable for everything a company does simply because they direct it. A shareholder is not the company simply because they own shares. That distinction matters. But like all legal principles, separate legal personality is not designed to be used properly for the purposes it was created. It is not intended to be used as a shield to hide the truth or hide assets. It is not intended to avoid legal obligations. It is not intended to manipulate situations to gain an unfair advantage. It is not intended to mislead courts. It is not intended to distort financial reality. This is where the corporate veil comes in. The veil separates the company from the individual, but the law allows that veil to be lifted. That is why the law has developed clear principles to address situations where the corporate form is being misused. The alter ego doctrine is one of those principles. It recognizes that in some cases, the company has no real existence of its own. It has no independent purpose, no separate will, no independent decision-making power. It exists only to carry out the wishes, interests, and activities of the person or group of persons that control it completely. When it is established that the law can lift or pierce the corporate veil, the legal barrier that separates the company from its owners, and treat the company as an affair or as the affairs of those who control it. So this is not something judges decide on a whim. No. It is not personal opinion. It is not usually exercised. It is not a usual exercise. It is based on well-established legal principles supported by statute, case law, and the rules that govern how legal proceedings are conducted. It is also closely linked to other fundamental rights and obligations that apply across the entire legal system. So we come to see these links clearly in key areas of law. Under the Marital Causes Act 1973, when courts deal with financial matters, property or rights following separation or divorce, they are required to be considered all assets and financial interests wherever they are held and however they are structured. The purpose of this is to ensure that all resources are taken into account and that decisions are fair and based on a full picture of the person's financial position. Okay, so this is not just a rule about money. It is a rule about justice. When assets are hidden behind legal structures, the full truth is hidden. And when the full truth is hidden, fairness becomes impossible. The Family Procedure Rules 2010 and especially Practice Direction 9A reinforces the need for proper financial disclosure in family remedy proceedings. Practice Direction 3AA also matters where vulnerability affects participation because a person who cannot understand or challenge complex company structures may be placed at a serious disadvantage. These rules and directions make clear that legal arrangements must be examined for their real effect, not just their formal appearance. Okay, real effect. Under the Human Rights Act 1998, Article 6 protects rights to a fair hearing. For the right to be meaningful, both sides must be on an equal footing. This is known as equality of arms. If one person can access information under the company structures and present their case effectively, while the other person cannot even see or understand the records, then equality of arms is placed at risk. If corporate structures are used to hide information or to create imbalance, it becomes impossible for a person to defend themselves, to assert their rights, or receive the justice they are entitled to. The Equality Act 2010 and safeguarding principles also play a vital part. These frameworks require fair treatment and, where appropriate, reasonable adjustments so that no one is placed at a disadvantage. When corporate structures are used to conceal assets or distort the truth, people are vulnerable or disadvantaged, including those who have experienced abuse, trauma, financial control, coercive control, may be placed at severe unfair advantage during an FDR. The law does not exist to protect those who exploit systems or hide the truth. It exists to protect people. It exists to ensure that justice is accessible to all, regardless of how financial affairs are structured. So what is the alter ego really? What is the alter ego doctrine? How and where does it apply? The alter ego doctrine answers a simple but powerful question. Is this company real, or is it just an extension of the person who runs it? When a company has no independent will, no independent activity, no separation of funds, and no genuine business purpose, then it is not functioning as a truly separate entity. It is an instrument, an extension, an alter ego. This alter ego doctrine is based on the idea that if the company is not truly independent, but is in fact just another way of acting on behalf of an individual or group of people, then the law can treat it as if it is that individual or the group that owns it. It removes the protection that the corporate form would otherwise provide for the company. It looks at who is actually in control. It looks at who actually benefits. It looks at substance rather than the label. Courts will apply its principle where certain conditions are met. So there is one single test that applies in every situation, but there is key factors that the courts consider when deciding whether to lift the corporate veil. So let's look at these factors in detail. First, purpose and use of the company. The first thing courts look at is why the company was set up and how it is being used. Was it treated for genuine commercial activity? Was it created to operate a real business? Was it created to provide goods and services, employment, contracts, investments, or commercial structure? Or was it created to be used as an improper purpose? Was it used to avoid liability, to conceal assets, to mislead other people or public bodies, to manipulate proceedings, to place assets beyond reach, to create one reality in court and another reality elsewhere? If a company is created or used for a purpose that it is improper, such as avoid legal obligations, hide assets, mislead people, or manipulate the facts of the case, this is a strong indicator that it may be functioning as an alter ego. For example, if someone transfers assets into a company they control, then claims personally that they have no money or property to meet their obligations to the court may ask whether the company is simply an extension of that person. This is not about judging legitimate business choices, no. It is about distinguishing between legitimate use or corporate structures and use designed to avoid responsibility or conceal the truth. Every legal structure has a purpose. When that purpose is honest and transparent, the law protects it. When it is used improperly, the law must intervene. So second, lack of independent activity. A genuine company will usually have its own business purpose. It owns its own operations, its own staff or resources, its own management, its own accounts, its own decision making, its own commercial purpose and interests. It will act independently of its owners or controllers. It will make its own decisions, pursue its own goals, and function as a separate entity in practical sense. But if a company has no real activity of its own and exists only to carry out instructions of those who control it, this suggests it may not be independent. No staff or staff actually, no operations, no decision making, no real commercial activity, just control. If all decisions are made by one person or group, if there are no separate management processes, if the company does not operate as a separate entity in any practical way, then it may be treated as the alter ego of those who control it. This is critical point. So if a company is just a shell with no employees, no office, no independent decision making, or real activity beyond following the direction of one person, then it may not be truly separate at all. It may simply be an extension of that person, but it can also have all these employees and still be used, and the law can recognize that reality. And thirdly, treatment of assets and funds. If the assets, money, property of the company are treated as if they belong directly to the people who control it, this is a clear sign of an alter ego situation. This can happen in many ways. Company money used for personal expenses, buying clothes and claiming that they are embroidery or t-shirts. Company property used for personal property dealings, like a wedding is paid for by the company and then they adjust the invoice. No clear separation between that belongs to the company. And what belongs to the individual, it belongs to the company. Funds move between different entities without a clear business reason. Personal bills are paid from the company accounts, such as the weddings. Personal assets purchased using company funds. There is no distinction. The company's resources treated as if they are controllers on resource. When there is no proper separation between the company and the people who run it, the law may see them as one and the same because of their actions. This is often one of the easiest things to spot. If someone can pay personal bills from the company account, buy personal property using the company funds, and treat the company's resources as their own, then the line between the personal and the company is blurred. That has disappeared completely. And when that line disappears, the law may remove the protection that the company form could have given otherwise or provides. So Number 4, degree of control and domination. The court will look at how much control is exercised over the company. If there is no such or a high level of control and domination, then that company has no separate mind, will or personality of its own. It may be treated as the instrument or an agent of those that control it. This is the core of the alter ego principle. It is not just about owning shares. It is not just about being a director or a CEO. It is not practical control. Who makes the decisions is the fundamental question. Who signs the documents? Who controls the bank accounts? Who decides what is paid? Who decides what is retained? Who appoints or removes directors? Who benefits from the company? Who uses the company's property? Who directs the income? Who decides how the company presents itself? So, complete control does not always mean formal ownership. It can be achieved through agreements, influence, financial arrangements, family members, nominees, shadow control, connected entities, a combination of factors. The court will look at the full picture to determine who is really in charge and who is really benefiting from the company's activities. Number 5, conduct and intent. Courts will look at the overall conduct of the people involved within that company. Fraud, mistreatment, or misrepresentation, actually, evasion, improper purpose, misleading presentation, avoidance of debts, defecting the rights of others, defeating the rights of others. If the company is being used to commit fraud, mislead others, avoid paying debts, or defeat the rights of other people, this becomes a key factor. The law will not allow people to use the legal structure as a way of escaping responsibility or hiding the truth. In the effect of using a corporate form to make it impossible for other people to enforce their rights or receive what they are legally entitled to, the court can intervene. When these factors are present, the court has the power to disregard the separate legal personality of the company. It can treat the assets, income, liabilities of the company as belonging directly to the person or the group that controls it. It can order documents and information from the company to be produced where relevant. It can make decisions based on the true position rather than the legal structure that has been created. This power is supported by many areas of law. Under the Companies Act 2006, companies are required to keep accurate records, file information about ownership and control, and provide transparency about their activities. So these requirements are designed to ensure that the corporate form is used properly and not as a cover for improper conduct. We also have powers under other laws, including the Criminal Finances Act 2017, the Proceeds of Crime Act 2002, and the regulations from the Financial Conduct Authority, which give courts and authorities additional powers to investigate financial arrangements, trace assets through different structures, and ensure that money and property are not being used illegally or improperly. These laws work together to ensure that those who seek to hide the truth cannot do so without consequences. So, the silo problem, how information is divided and isolated. Now we come to that part that makes this area so complex and so dangerous. We have the law, we have the principles, we have the court and the court's powers, we have company law, we have financial remedy law, we have disclosure duties, we have tax law, we have land registration, we have criminal finance legislation, we have data protection frameworks, we have regulatory bodies, but all of these tools only work if the information is available, okay, if it can be found, if it can be connected, and if it can be brought before the court in a way that reveals the full picture. So, this is where the silo problem begins. So each authority holds partial truths. HMRC holds income. Companies House holds structure. Land Registry holds ownership. Courts hold disclosure. But these systems do not automatically connect. They do not reconcile. They do not cross-verify. Information about companies is recorded at Companies House under the Companies Act 2006. That may include directors, persons with significant control, share structures, annual accounts, confirmation statements, registered charges, appointments, resignations, and filings, and information about income tax, profit, gains, and liabilities may sit with HMRC under the tax regulations, legislation including the Income Tax Act 2007 and the Commissioners for Revenue and Customs Act 2005. So information about property title is held at HM Land Registry under the Land Registration Act 2002. So information about court proceedings sits within the court files, pleadings, statements, Form E, disclosure, financial remedy documents, ordered or orders by the judge, and the bundles supplied by the legal teams. Information about banking transactions sits with financial institutes. Information about suspicious activity, unexplained wealth, proceeds of crime, or financial misconduct may sit within entirely separate regulatory investigation or enforcement frameworks. Each system holds part of the truth. But the problem is this: the systems do not automatically speak to each other. Companies House may show one picture, HMRC may hold another, the Land Registry may show another, the banking records will show or reveal another picture. Okay? The family court may only see what one party chooses to disclose, and when that happens, truth becomes fragmented, because a person can say one thing in court and file another picture through a company. They declare another position for tax purposes, hold property through another structure, move money through another account, and unless these systems are joined together, compared and tested, the contradictions may never be seen. This is not just inefficiency, this is structural risk, the gap I spoke about in an earlier episode, because when the burden falls on one individual to uncover what multiple state systems already hold in fragments, equality of arms becomes a theory, is theoretical. If one party controls the companies, the records, the accounts, the banking, the filings, the property arrangements, and the disclosure narrative, and other party is left trying to reconstruct the truth from fragments, then the system is no longer operating fairly. It is asking the weaker party to do the work of institutional intelligence. That is not justice. That is evidential discontinuity. And this is where company law becomes dangerous. When it sits inside silos, separate legal personality protects legitimate enterprise. But siloed information can conceal. The corporate veil protects business separation, but silo systems can make that veil impossible to test. So data protection protects privacy, but siloed data can leave courts blind to relevant truths. Tax confidentiality protects taxpayers' information, but a court cannot make a fair financial order if official financial truth is never connected to the evidence before it. The question is not whether privacy matters. It does. The question is not whether company law matters. It does. The question is whether systems should remain so disconnected that false or incomplete narratives can survive simply because no one is required to connect the records. So this is the legal and structural failure. Because under the Marital Causes Act 1973, the court must consider the full financial reality under the Family Procedure Rules and Practice Direction 9A. Financial disclosure must be full frank, and properly supported. Under Article 6 of the Human Rights Act 1998, both parties must have a fair opportunity to present their case. But how can a person have a fair opportunity if one side holds the entire financial architecture and the other side is left outside of the data? How can there be equality of arms if one party understands the corporate structure and the other cannot even see the record? How can there be a proper disclosure if company information, tax information, property information, and court disclosure are never reconciled? So this is the silo problem. And when a silo remains unchallenged, they become a hiding place. Not always intentionally, but structurally. A hidden place for contradictions, a hidden place for concealed assets, a hidden place for inconsistent narratives, a hidden place for false poverty, a hidden place for corporate wealth, a hidden place for beneficial control, a hiding place for financial distortion. The result is evidential discontinuity, incomplete disclosure, structural imbalance, legal misrepresentation, and the key failure is simply the court relies on what is presented before it, not always what exists. And when truth is hidden in silo, justice is left in the dark. So, corporate structures can be used to distort financial reality. Corporate structures are not inherently wrong. Let us be very clear about that. Okay, so companies are legitimate. Assets protection can be legitimate. Business planning can be legitimate. Tax planning, when lawful, can be legitimate. Limited liability is legitimate. Separate legal personality is legitimate. The problem begins when legitimacy is used to cover when a structure designed for lawful commercial activity becomes a tool for distortion of personal financial reality. The court must look carefully. There are several ways this can happen. First, assets can be placed inside a company, and that can be described as unavailable personally. A person may control the company, benefit from the company, use the company's assets, direct the company's decisions, and yet say in court, "This is not mine, that belongs to the company." But the court must ask, who controls the company? Who benefits from it? Who uses the assets? Who directs the income? Who decides what is paid out? Who decides what is retained? Who decides how the company presents itself? If the answer points back to the same individual, then the court must consider whether the company is genuinely a separate in practice or whether it is operating as an alter ego of that person. Secondly, income can be distorted or retained inside companies. So, a person may appear to have low personal income. Business money is not taken as salary, but income may still exist in the structure. So funds may be retained as company profit. Benefits may be received in kind. Personal expenses may be paid by the company. Directors' loan accounts may be used. Dividends may be delayed. Payments may be routed through connected entities. On paper, personal income may appear low. In reality, financial resources may be substantial. This matters because Section 25 of the Marital Causes Act 1973 is concerned with resources, needs, obligations, and earning capacity. So if income is artificially supported or presented selectively, the court's assessment becomes distorted. Thirdly, liabilities can be created, inflated, or presented strategically. A company may show debts. Loans may appear. Directors' loan accounts may be relied upon. Intercompany balances may be presented as obligations. Invoices may be raised. Payments may be deferred. Sometimes liabilities are real. Sometimes, and some may be questionable. The court must ask, is this liability genuine? When it is created, who benefits from it? Was it created before or after proceedings began? If there is documentation, was money actually advanced? Is repayment being demanded? Is it commercial? Is it being used to reduce apparent value? 4. Assets can be moved between companies or connected parties or persons. A business may transfer assets. A director may resign. Shares may move. A new company may be formed. A company may become dormant. A second company may take over activities. Intellectual property may be moved. Contracts may be assigned. Goodwill may disappear from one entity and reappear in another. So each step may be explained commercially, but when examined together, the pattern may suggest something else is happening. This is why the courts must look at substance over form, because financial manipulation often does not appear in one dramatic act. It appears in a sequence. A transfer here, a resignation there, a new company there, a changed filing there. a reduced valuation there, a delayed account here, a disputed disclosure, a claimed liability, a missing document, and convenient insolvency. Individually, each may be explained. Together, they may reveal a structure designed to obscure the truth. This is where the alter ego doctrine, veil lifting principles, and family court disclosure powers become crucial, because justice cannot be defeated by complexity. Complexity must be examined. So, the collusion between company law, and family law. Company law and family law ask different questions. They do. Commercial law asks, who owns the shares? Who are the directors? What is the company's separate legal identity? What is the filing? What its accounts? What are its accounts? What are its liabilities? Family law asks, what are the parties? Who are the parties? The resources. Who are the parties' resources? What income is available? What assets exist? What needs must be met? What is fair? What is the true financial position? These questions overlap, but they are not the same. A company may be separate in company law, but still highly relevant in family law. A company may own an asset, but the court may still need to consider who controls that company. A person may not personally own property, but may control a company that owns it. A person may not take income directly, but may control when and how company funds are distributed. A person may say an asset is unavailable while benefiting from it in practice. This is why the family courts must not be trapped by labels. It must ask practical questions. What does this person actually control? What can they actually access? What resources are available to them? What structures exist? What is the purpose of these structures? What is the timing of any transfer? What does the disclosure show? What does the financial record show? Does the records match? Where the record do not match, the discrepancy matters. If a person says in court they have limited resources, but company filings suggest otherwise, that matters. If a person says a company is insolvent, but public records show significant activity or assets, that matters. If a person says they have no control, but company's house show directorship, shareholdings, or significant control, that matters. If a person says an asset is unrelated, but Land Registry or company's house or company records show connected ownership. That matters. If a person says income is low, but HMRC or company's house suggests different financial capacity, that matters. This is not about attacking companies. This is about ensuring that the court is not misled by incomplete disclosure, because financial remedy proceedings cannot function if corporate records and personal disclosures are not reconciled. And where there is vulnerability, domestic abuse, coercive control, or financial abuse, this becomes even more important, because the party who has been excluded from financial information may not know what companies exist. They may not know who owns what. They may not know what filings mean. They may not understand accounts. They may not know whether money has been moved. They may not have the resources to instruct forensic accountants. They may not have the capacity to investigate corporate structures while traumatized. So, if the system does not assist in connecting the information, the imbalance becomes entrenched. That is why this is not only a company law issue, it is an access to justice issue. It is a safeguarding issue. It is an Article 6 issue. It is an equality of arms issue. It is a family justice issue. So when corporate misuse becomes a safeguarding and human rights issue, we must now move to the technical language, because behind every company structure, behind every filing, behind every asset transfer, there is a human consequence. When corporate structures are misused in financial proceedings, the consequences are not abstract. It may determine whether a person keeps their home. It may determine whether they can rebuild. It may determine whether children are properly provided for. It may determine whether financial abuse continues after separation. It may determine whether a survivor remains trapped in poverty while assets are hidden behind complexity. It may determine whether the court sees the truth or performance. This is why the issue becomes a safeguarding issue. Financial abuse does not just end when proceedings begin. Coercive control can mutate in litigation control. The person who once controlled bank accounts may now control disclosure. So, the person who once controlled access to money may now control access to documents. The person who once controlled the narrative inside the relationship may now control the narrative inside the court. And if the corporate structures are part of the control, the court must recognize it, because otherwise the legal process may become the continuation of the abuse, the weaponization of the system, not through violence, through complexity, through delay, through manipulation of disclosure, through cost, through silence between systems, through forcing the vulnerable party to prove what they cannot access. This is where Article 6 matters the most. A fair hearing is not fair if one party can hide behind corporate structures while the other cannot test them. Equality of arms is not equality if one party holds the documents and the other holds only suspicion. Natural justice is not satisfied if one party is heard through polished financial presentation while the other is unable to expose the structure beneath it. And Section 25 cannot be applied properly if the court is not seeing the full financial landscape. So this is why the silo problem becomes a human right problem, because the right to a fair hearing depends on access to the truth, not partial truth, not selected truth, not corporate truth in one system and personal poverty in another. The full truth. So professional duties, authority and oversight, as well as accountability. The issue also arises where professional responsibility is misused. Companies do not prepare themselves. Accounts do not file themselves. Legal arguments do not present themselves. Financial narratives do not emerge in isolation. There may be solicitors, barristers, accountants, tax advisors, commercial formation agents, financial advisors, banking professionals, directors, officers, shareholders, persons with significant control. Where professionals are involved, professional duties matter. Solicitors must not mislead the court. Barristers must act with integrity. Accountants must not produce misleading accounts. Directors must comply with duties. Companies must keep records. Regulated professionals must not assist concealment. This matters because complexity can be professionalized. A structure may look sophisticated. A document may look formal. A filing may look compliant. A legal argument may sound technical, but sophistication does not equal truth. Professional presentation does not equal integrity. A structure can be lawful in form and still raises serious questions in context. The court must be able to look beyond the polish. It must ask, does this structure reflect reality? Does this filing match disclosure? Does this account match lifestyle? Does this company match the claimed financial position? Does this ownership match the control? Does this reality match the evidence? Does this narrative match the records? When the answer is no, accountability must follow, because systems cannot allow professional complexity to become a shield for a financial distortion. And where professional presentation financial structures, they must not do so with candor. They must not obscure. They must not mislead the court. They must not rely on technicality to defeat truth. They must not allow legal personality to become a mask for false disclosure. The duty to client exists, the duty to the court exists, but the duty to the court and the duty to the administration of justice also exists above all. And where those duties meet, integrity must prevail. So what reform must look at, or what does that actually look like? In this section, we will it is not to destroy companies' law or try to isolate it or remove the legitimate corporate protection. The solution is not to uncontrolled data sharing. The solution is lawful integrity, the structural verification, the targeted disclosure, proportionate information sharing. The court directs cross-checking, transparent audit trails. Where companies' structures are relevant to financial remedy proceedings, the court must have practical mechanisms to test them. This may include cross-checking companies' house filings against Form E disclosures, requiring full company accounts, not only abbreviated account filings. Examine persons with significant control, reviewing directors' loans accounts, investigating asset transfers between connected persons or entities, checking the Land Registry ownership against the corporate control, considering tax information where lawful and necessary, ordering expert valuation of businesses and business interests, requiring an explanation of corporate liabilities, drawing adverse inference where disclosure is not complete or misleading, ensuring vulnerable parties are not left to investigate complex corporate structures alone. This is where SafeChain becomes central. So, because SafeChain is about evidential continuity. It is about eliminating the gaps between the agencies. It is about ensuring that truth does not disappear between systems. It follows each process, each procedure. It's about connecting, safeguarding, disclosures, participation, financial, evidential, and institutional accountability. It is about organizing and recognizing that justice cannot function where evidence remains scattered. A modern legal system must be able to see across structures, not to violate privacy, but to verify truth. No, not to undermine legitimate businesses, but to prevent misuse. Not to punish complexity, but to stop complexity from defeating fairness. Because when HMRC Company House, Land Registry, courts and agencies do not speak to one another, the person seeking justice is left to fight in shadows. And justice should not depend on whether a vulnerable person or a vulnerable party can solve the state's fragmentation alone. That is a state problem. So, let us return to the key message where we started. One system holds the truth, another never sees it. And when the corporate veil hides behind the silo systems, justice is left in the dark. This is the issue. Companies' law matter. Separate legal personality matters. The corporate veil matters. Privacy matters. Data protection matters. Commercial certainty matters. But none of these principles should be used to obscure the truth and defeat disclosure, conceal assets, or undermine the right to a fair hearing. A company can be separate, but truth must be connected. A corporate structure can be lawful, but it must be transparent when fairness requires examination. A filing can sit at company's house, but if it contradicts what is in the court or before the court must be able to know. A tax record can sit with HMRC, but if it reveals a different financial reality, justice must not remain blind. A poverty title can sit with a property title can sit with the Land Registry, but if that reveals hidden control, it must not be ignored, because justice cannot function on fragments. Justice requires continuity. Financial remedy proceedings require full truth, full and frank disclosure. Company law requires integrity. Human rights require fairness. Safeguarding requires protection. And the public requires confidence that the law is not being used as a tool to hide what justice needs to see. So, the question is not whether the corporate veil should exist. It should be. The question is whether the corporate veil should be allowed to hide behind institutional silos. It should not. because when systems do not speak truth, truth becomes fragmented. And when truth is fragmented, fairness is structurally denied. The corporate veil is not the problem. The silence between systems is. When systems do not speak, truth does not exist in the place where justice needs it the most. And when truth does not exist where justice needs it, justice cannot stand. So, a justice system that cannot connect the records, it cannot see the truth. And where the truth is hidden behind corporate forms and institutional silos, fairness is not merely delayed, it is structurally denied. So, if this episode resonated with you, please share it with someone that needs to hear it. Thank you.